The mixture of constitution making, constitutional design, and the choices of a constitution are particularly important in colonial, post-colonial and conflict prevention and resolution situations. Why? Because the extent to which you involve the broadest possible range of interest groups, and the extent to which the ordinary people of the country gain understanding of the process and of the constitution, have huge impacts on whether a constitution meets the needs of that country. Where constitutions are made by elite negotiation or imposed by a particular group, it's almost inevitable that the resulting content of the constitution will be unlikely to really meet the broad range of needs. It just makes sense. One of the advantages of the kind of process which was followed in Fiji in making the 97 Constitution and in making Bougainville's fourth Constitution, the only one that never became a Constitution, that's the 2012 Constitution, both of those had that advantage of being very inclusive, the processes, which I think led to them having, you might think they're perfect, there might be all sorts of problems with them, but the solutions that they offered to the management of society in Fiji reflected the broad range of views that had been fed in. And I think because the people had been consulted, there was a degree of legitimacy in what was recommended in both of them. So process is really important. I want to start, before I get into the detail of thinking about the 2013 Constitution and the process by which it was made, and whether there are avenues for review and amendment of what appears to be on the face of it a virtually unamendable Constitution. But before I do that, I just want to reflect a little bit on what we might have learned through the experience of constitution making processes and constitutional amendment processes in Fiji's history. Because, of course, I would say Fiji's had 5 constitutions: 1970, 1990, 1997, 2012, that wasn't passed, of course, and 2013. That's quite an impressive weight of documentation. I know of no country in the world, I haven't done a detailed study, but I know of no country that's had 5 or maybe you could say 4.5 or 4 1/4 constitutions. And why is that Fiji has so many constitutions? It's to a large extent because the processes have not overall been so good, and the choices made in constitutions overall have often, I think, not really met, not in all cases, as I said, but perhaps have not really met the needs of Fiji. And that's invited what the Supreme Court recently talked about. They commented on the difficulty in interpreting the current constitution, where, as they say, we'll come to this a bit later, they point to the wording of quite important provisions of the constitution as being literally unintelligible. It's not proper English. And they've then had to go and try and interpret what was intended. But they point to one of the difficulties being Fiji's fractured history of coups and other political problems, resulting in constitutions only lasting very short time. So even the court's concerned about that, and the court mentioned, not exactly critically, but not very favourably, the lack of public consultation in the process to make the 2013 Constitution. So, what have we got in these constitutions? Let's have a quick look at them. I think we've got to remember that Fiji's a post-colonial state where 100 years of the policy of the colonial regime had significant impacts on the country, most notably in the complex population mix, of course, of Italke, Indo-Fijian, and others. And during that colonial period, as the population became more complex and mixed, the colonial regime policy was basically to keep them separate. There were, in many ways, you can understand the reasons why that was at the time. But it then set up a very difficult situation to deal with as you approach independence, because communities that were by then roughly equal in size and had been kept separate, had to work out how they were going to work together in the independent state. So the natural thing was to some extent keep what had been in place operating under a new system. And so the Constitution was negotiated basically in London between elite fractions of the Fijian, the Italke and the Indo-Fijian population. And the Constitution, the 1970 Constitution, I'm sure you're aware, was not adopted by the Fijian Parliament, it was adopted by the British Privy Council and was a schedule to an order of the British Privy Council. It came out in the name of the Queen. So what we have here in that first Constitution, as it appears on Pack Lead now, the first few pages are the Order in Council. And the Constitution comes about 9 pages in as a schedule to what the British had decided. Schedule to the order, the Constitution of Fiji. So choices were made then to basically try and continue the same sort of separation of the two main communities. And the focus was on rights of the communities, as if they were sort of hegemonic entities. They had rights to seats in the parliament, as you know. And there were various other categories of rights, particularly for the Italke. That focus on communal rights rather than any sense of integration and individual rights was written right through the Constitution. That same kind of framework then came under attack, came under threat when the first real shift in power happened in the 1986 elections. And that, of course, led to a coup. And then in the 1990 Constitution, to a large extent, there was an attempt to keep in place the same sort of dispensation, the same sort of separation of communities and vesting of community rights. But it was not working. And that was eventually clearly recognised by the regime under the present Prime Minister, and earlier than was anticipated under the 1990 Constitution. Of course, you had the constitutional review process set up, which tried to find a new way ahead of a more integrated system, less separation of the communities, and more focus on individual rights. And of course, the parliamentary committee that reviewed the Reeds Commission report watered that down quite a bit, shifted it back to a bit more of a communal focus, but it did make a shift in that direction. So the constitution making processes then kick in. because you've got a much more open process in 1995-96, leading to the 97 Constitution, it's that, I would say, opening up the process, taking it away from elite negotiation or elite imposition, which you could say was what happened with 1970 and 1990 Constitution. The 1997 Constitution was opened up to a large extent by the process, and that pushed it towards a different framework. That all, of course, then came under attack, not through a military coup, and this is important, I think, but by a coup initiated by others. Yes, there were military involved, but it was not initiated as a military policy, the 2000 coup. And in fact, it was the military that strongly opposed, the military as a body, that strongly opposed it. But that's led to another unfortunate, I suppose, first of all, a serious attempt to open up the constitutional choices after the 2006 coup. The Guy Commission was a serious attempt to open up to choices again, but that got shut down because it wasn't acceptable to the then military regime. And again, there was an imposition of a constitution without a process that opened up the way to consultation and participation. So we've got those 5 constitutions. The first one lasted 17 years, and then it was followed by 3 years without a constitution. The next one lasted 7 years, from 1990 to 1997. Then there was only 3 years initially under the 97 Constitution, and that was followed by another year or so without a constitution. So there was a period there under the 97 Constitution when it effectively did not operate, when Bainimarama, etc. were in charge. Then from 2001 until 2006, the Constitution operated. Then I'd say really, although Bainimarama said that he was mounting a coup to protect the 97 Constitution, in fact, of course, the 97 Constitution did not really operate from the end of 96, and so from the end of 2006. So from the end of 2006 until 2013, you operated in Fiji effectively without a constitution. 2013 to the current, 2024, is 9 years. So it's the second longest period of constitutional continuity. But I'd say it's not been a good record this last 9 years, and we'll come back to that. It's worth noting that we've had the 4 constitutions plus 1, various periods operating under the constitutions, none of them for very long. Even the 1970 Constitution, 17 years is not particularly long. And you've had 9 or 10 years with no constitution at all. That's a remarkable history. I know of no country in the world that's had so many constitutions, and it reflects a lack of consensus on what the best way ahead is. Let's turn now to the process a little bit more. In terms of constitution making process, it was once very common for them to be made by expert committees, always of males, of course. In independent constitutions for the colonial territories that were becoming independent, there was a heavy influence of the departing colonial powers, and there was an assumption in both the Francophone and the Anglophone countries, even in the Portuguese, there was a natural tendency for negotiation of the existing elites who were seeking to protect their existing interests, and so tended to do so under the existing colonial arrangements. Mostly in these former colonies, the initial constitutional settlement failed eventually because there were various internal problems and contradictions that hadn't been anticipated, largely because the process was not open and inclusive, I'd say.